privilege. I am not. How did you get that information supposedly from my chambers? Did somebody tell you? I'm not. You should have told me. You got 5 minutes. Well, I don't need it. I want to continue. This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
I never heard this happen before, but Young Thug lawyer was arrested about a week ago during trial for criminal contempt. And so we're going to dig deep into that today. And so Young Thug, he currently on trial for RICO charges. Young Thug is known to be, of course, a rapper, but also his label is YSL. And so the state of Georgia is claiming that YSL is actually a criminal organization, and they're charging Young Thug of alleged crimes that came out of that alleged criminal organization. So a little law on RICO real quick, Georgia law. There's a federal statute and of course a state statute in Georgia for RICO. The federal statute may be tougher to convict on, but from what I'm finding out, the state statute in Georgia is actually more stringent, meaning that, hey, they more likely to be convicted under the state statute in Georgia for RICO laws than you are in the federal statute. So here it says a person may be charged under the RICO statute if they participate into an interrelated pattern of criminal activity motivated or resulting in monetary gain or economic or physical threat of injury. And so just to sum that up, as I mentioned earlier, the RICO charge is a charge usually when a person is the head of an organization. He's charged with the crimes that people under him committed. So back to this trial. So Young Thug's lawyer, this happened on January 10th, 2024. Young Thug's lawyer had found out about an ex parte meeting without the other side's knowledge. An ex parte meeting between the judge, a sworn witness that previously refused to testify during the trial, and then also the prosecutors and their sworn witness attorney. Not Young Thug's defense attorney, that witness's own attorney. That witness name was Kenneth Copeland, and he's known as Lit With It. Never heard of him, but Lit With It, now everybody knows. Brian still believes this meeting was improper, as do I. I think that's crazy. There was a meeting with a sworn witness without the defense counsel being put on notice. How can the defense prepare for whatever they asked the witness in that meeting? So a little bit on ex parte law, and I'm gonna tell you about how we handle ex parte matters in Mississippi. It's used differently in state to state, but generally ex parte means a meeting or a hearing out the knowledge of the other side. For instance, in Mississippi, you may have an ex parte communication with the judge if you haven't served the defendant. So of course, I've got a family law case, and I'm trying to get a court date for the family law case to serve the defendant. I am going to ask the judge for a court date so I can serve the defendant, be there at that time. This is parte communication with the judge. Another time is if I haven't served the defendant in a civil matter, and the 120 days time limit to serve the defendant in Mississippi is coming up, I'm a motion to the court and ask the judge, hey, can I get more time to serve this defendant? Those are some examples of ex parte matters in Mississippi. Now, those are the exceptions. In Mississippi, 90% of the time, any communication you have with the judge's office, you have to CC the defense counsel, or at least let them know, like, hey, I'm gonna call the judge and see when can we get a hearing. You want to put the defense counsel on notice. You CC the defendant, even if it's not represented. You email the judge and he's been served, you CC the defendant in the email. You write the judge a letter, you send the defendant a copy of the letter. That's like the standard practice. And if the defendant's represented, you CC the defendant's counsel in the email, the letter. You don't have ex parte communications outside those exceptions. In Georgia, from the research I've done, they do allow some exceptions for ex parte meetings. But in the research I've done, it's usually just the judge and maybe the attorney. I didn't find too many instances where it's the judge and the attorney and a witness that was sworn in. And so I think Brian Steele was perfectly correct in bringing up that this meeting was improper, because I think it was improper.
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can.
So in court, as Brian Steele is telling the judge about this meeting and bringing this to the judge's attention during court, the judge gets really upset. Not about the fact that the meeting happened. He's upset that Brian Steele found out, which I think overshadows that how the meeting that they had with a witness could be possibly improper. And so Brian Steele tells the judge that he found out about this meeting. He asks for a mistrial. The judge says, hey, this meeting was not improper. We didn't have to put you on notice. And then Brian Steele continues to say that this should be a mistrial, and the judge just started hammering him about who told you about this? Who told you about this? And Brian Steele says, no, I can't give up this information because it's privilege. It's between attorney-client privilege. The judge disagrees, like, no, this is not attorney-client privilege. You're not protected by privilege. Who told you this information? And Brian Steele continues to say it's privilege and refuses to tell him that. And this goes back and forth for some time, at least about 10 minutes. And the judge gets very upset that Brian Steele is not telling him who told him. And the judge finds Brian Steele in criminal contempt. He orders that Brian Steele is arrested. And I'm like, wow, this is crazy. Real quick, some law attorney-client privilege. Attorney-client privilege protects confidential communications between a lawyer and their client that relates to their client seeking a legal advice or services. So in sum, whatever you tell your lawyer in regards to the case you get legal advice and him representing you, it's attorney-client privilege. A lawyer cannot tell nobody else the information unless you agree to it. And it also covers written communication. So just not me and you talking, it's written communication, text messages, things of that nature. And so they go on back and forth for a few more minutes. The judge believes that this does not qualify as privilege. Brian Steele continues to say, hey, this should be a mistrial. Number one, because of the improper meeting. Number two, now I'm being arrested. And my client does not have the attorney. You deny his right to an attorney. So this should also be a mistrial for those reasons. And so Brian Steele steps away from the podium a little bit. I think other attorneys on the defense side says, hey, I have this same information, and said this should be a mistrial. And so Brian Steele, as he's been arrested, also requested that he be held in the same jail with Young Thug so they can prepare on the court. And I think that will go down as like a lawyer moment forever. And they're going to be talking about that in law schools forever and showing videos like he wanted to be arrested, be in jail with his client. And so I feel like Brian Steele knew what he was doing. He's like, hey, I might as well make something good out of this and make a show like, hey, put me with my client so we can prepare for court. You already denied his right to an attorney. And this is a mistrial because you had a meeting with a sworn witness and didn't tell anybody. And so, hey, Brian Steele, do your thing, man. You're a legend now. And so Brian Steele was sentenced for 10 weekends in jail. So that's 20 days. And so in Georgia, criminal contempt of court is a misdemeanor that occurs when someone intentionally disobeys a court order. The penalties for criminal contempt are a fine up to $500 and 20 days in jail. And so that's what Brian Steele got. I don't know about monetary fine, but he got 20 days in jail. And so, and you'll see that in the video that Brian Steele continues to make arguments that's mistrial and there's this information about who told him is privilege.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So For that reason, additionally, I asked for a mistrial. And I assume you denied, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
When he was finally taken out of court, someone announces in the video that, hey, there's 20 lawyers outside that want to come in and speak. They want to speak on the behalf of Brian Steele. They're angry that he was arrested during trial while defending his client. And of course, the judge didn't let him. And so Brian Steele later appealed his sentence, and that his sentence was held in abeyance while the appeal goes on. So he don't have to serve those days. He's not in jail this weekend as I'm shooting this video. There is a future hearing set by this court. The judge was still trying to get down to the matter of how Brian Steele found out about that meeting. And I'm sure he wants to send somebody else to jail. He wants to fire a staff meeting that Brian Steele found out about this meeting. And Brian Steele filed a motion this past Monday on the 17th, asking the judge to recuse himself. And again, he requested a motion for mistrial. And then another lawyer, defense lawyer, in this matter filed a motion that the judge recuse himself of misconduct. And so here's my thoughts. My thoughts like this is crazy. And I kind of want to clear up what I said earlier. I have heard of a lawyer being threatened with criminal contempt, but it was not during a trial. It was not because the lawyer was raising up a defense of privileged information, And so I never heard anything like this before happening during the trial. And so me personally, my mind was just blown. I feel like the judge let his pride get to him. I feel like that he shouldn't have arrested Brian Steele, because I think Brian Steele did what any other lawyer would do in his situation. I found out about a meeting with a sworn witness that I wasn't made aware of. I'm gonna raise some objections to that meeting. Okay, I should at least been put on notice if you did not want me there. Because how can I prepare about what you all told this witness in chambers, and I wasn't there to cross-examine this witness? So I think the meeting was improper. I didn't see what the law allows an ex parte meeting with the judge and the prosecutors and the sworn-in witness. Now I did see there was some exceptions where you could have a meeting with the judge and the prosecutor, and an ex parte meeting. But I think the defense counsel still needs some kind of notice that one was happening, but they didn't want him there for safety reasons or something like that. And we don't want you to tell your client because of safety reasons, But other than that, if you having an ex parte meeting, I really believe you need to put defense counsel on notice and give him a reason why you don't want him there or why you don't want his client to know. And that's what they should have done here. They should have told him that before then. I need to find some more law to back that up. This is me using my mind, my legal mind, and what I would think. And so I would love to hear the outcome of these issues. The main issue is if there was an ex parte meeting with a sworn witness and prosecutors, and even that witness attorney, without the knowledge of defense counsel or the defendants on jail, is there cause for a mistrial? My gut feeling, I want to say yes, but we don't know the answer to that yet. Then also number 2, can the lawyer be arrested for criminal contempt if he's alleging the information that the judge is seeking is privileged? And I think a third issue is if a lawyer is arrested during trial, is there a mistrial because he was arrested? Because now the defendant does not have a lawyer. And so those are 3 issues that I think are very important, and I would like to have the outcome of that. One thing I think Brian Steele did real good was that he was up there for a while, and I think what he was trying to do was, show everybody that he was selfishly representing the client. And I may have not went back for that long, but I definitely would have made sure that I had all my issues on the record for appeal. What lawyers do, if we get overruled on an issue or a motion or something is denied, then we make sure we have that on the record. Because if you don't bring that up on the record, then you can't appeal that issue. So having something on the record is saying it in open court or saying it on deposition, and you got a court reporter typing it up. It's on the record. It's in open court. We're in court. And so now that's an appealable issue because that issue you brought up, that motion you brought up was denied. It was ruled against, so now you can appeal that. And I'm sure that if Young Thug is convicted, there will be an appeal, and he's going to bring up those issues. I think he did a good job on that. I want to add one more quick thought to this. I really want to see what the judge has to say. Even though I don't agree with him, I want to get his perspective. He issued a written order of contempt for Brian Steele, and I read it. He was citing some law on contempt and things of that nature, but he didn't cite any law that says you can have a ex parte meeting with a sworn witness. And so I would like to hear what he got to say, and I think it'd be very interesting. And so I kind of can't wait to see the outcome of this. I'm gonna keep my eyes on this trial now. I knew it was happening, but it was kind of like in the background. I wasn't paying no attention to it, but now all eyes on it, on the trial, because wow, the lawyer got arrested during court. You don't see that every day. And so if you like this video, I hope you learned something. I try to explain stuff where people can understand. And so I have another video that's dealing with rappers and law. It's Drake versus Kendrick. Can they sue each other for defamation?